Hello, everyone. It's 5 o'clock. Welcome to this session. The Greater New York Chapter, ELSA organization is happy to present. We're going to be talking with Elisha Wellerstein about estate planning. And I'm going to first just give you a little bit of information about Mr. Elisha Wellerstein. He is the founder of the Wellerstein Law Group. He has many years of experience as an accountant and business consultant prior to becoming an elder care attorney. His legal practice focuses on estate planning, Medicaid, elder law. Practice covers Long Island, Manhattan, Queens, and Brooklyn. He's very busy, but he's even gone outside of that borough as well on a few occasions. I've had the pleasure of working with him for the last couple of years, I think 3 years, and very happy that he's doing a presentation today. It's a very important topic. And with that, I'm going to hand it off to him to do his presentation. We're going to have a question and answer at the end of the presentation. So please feel free, as he's even doing his presentation, if you want to put in a question because you might just forget by the end, that's fine. And at the end, we will definitely have those questions answered. Okay, thank you very much, and take it off, Lisa.
Thank you, Michelle. Thanks for that kind introduction. Hi, everybody. Welcome. Thanks for joining me. So today's topic, we're going to be talking about, how to plan for long-term care, protecting your income and assets. So I'm going to share my screen over here. Hopefully that will bring it up. Okay. And as Michelle said along the way, I may answer your question while we're going through this. Either send us your question and we'll address it at the end, or at the end you'll be able to ask us. Okay. So planning for long-term care, protecting your income and assets. So what we're going to talk about, just to give you a brief overview, we're going to talk what we call a basic estate plan. What is long-term care, ways to pay for long-term care, and the cost of long-term care, what's Medicaid and how to qualify for Medicaid, even if you have assets and a higher income. A little bit about myself. All right, let's skip all that stuff. Okay, so estate planning. So in my office here, we call a basic estate plan your will, power of attorney, and healthcare proxy. The will is your most popular document that people are aware about. Your will dictates, gives direction to the court of where your assets go when you pass away. That process is called probate. If somebody passes away without a will, here in the state of New York, that's you're passing intestate. So the laws of intestacy are the ones that take over. And I'll go over briefly what that means. So in New York, if you pass away, if you didn't create your own will, the state has basically created their own will for you. So if you're married with children, and you pass away without a will, then the state states that roughly first 50% of your assets that are probatable go to your spouse, the other 50% go to your children. If you have children but no spouse, it goes all to your children. If you have a spouse but no children, it goes just to your spouse. And if you have no spouse and no children, then it kind of goes back up. It goes to your parents and then to your brothers and sisters and things like that. In your will, the will is an important document, especially if someone has minor children, because in your will, what you're going to do is you're going to appoint, I'm sorry about that. You're going to appoint an executor. Sorry about that, guys. You're going to appoint an executor. The executor is a person who's in charge of the estate. Your beneficiaries, those are the people who are going to receive your assets. And in your will is where you're going to state who the guardians of your minor children are. So even if you have no assets to pass along, or if all of your assets are passing outside of probate because let's say they're financial accounts and you've named beneficiaries on them, if you have minor children, a will would be really important to make sure that you appoint a guardian. So this way your children don't enter, the foster care system, God forbid, or something like that, or that your choices aren't carried out. The next document, so that covers the will. Like I said, it's probably the most important, the most common document people hear about. I actually find in my practice, it's not the most important document because, like I said, if you don't have a will, then the laws of intestacy apply. Generally speaking, we see people are usually doing something standard to my spouse, to my children, something like that. In addition, The only assets that are going to pass within the confines of your will are assets that don't have a beneficiary listed on them. So if you have financial accounts, you've named a beneficiary, retirement accounts, annuities, anything like that, those beneficiary designations overrule anything in your will. So you do want to make sure that your beneficiary designation does match your will. Real property that's jointly owned also passes outside of probate. So this isn't the most important document. The most important document we find is the power of attorney, because without it, it really creates a lot of trouble. So the power of attorney is a legal document where a person is appointing an agent to be able to act in their place. The power of attorney we create is a durable power of attorney without any conditions. Usually, those are the ones we usually recommend. It means that once you sign it, it's in effect. By signing the power of attorney, you're giving your agent authority to act in your place. We try to give as much authority as possible. There is a standard form, which is kind of generic. And at my office, we will add in a few pages worth of modifications so the agent has authority to do things as estate planning, Medicaid planning, transfers to trust, creating trust, changing beneficiaries. And the reason why we find this is the most important document, especially in a presentation like this, is because without a power of attorney, if a person loses capacity to be able to make decisions for themselves, you would have to go through a guardianship proceeding. The guardianship proceeding is intrusive, it's cumbersome, it's petitioning the court, asking, someone would have to petition the court asking to be appointed to take over for you. You're going to spend thousands of dollars. It's going to take a few months. It's not a seamless transfer of your authority, and you may not be picking the court may not agree with who you would have appointed. With a power of attorney, you would be able to pick the person you want, and that person would be able to take care of your finances, make decisions for you, legal decisions for you, without needing any court intervention. We also, in our office, make sure we appoint a gift writer. So under New York law, if you want your agent to be able to make gifts, to whether it's a transfer of assets into a trust, a transfer of assets to others, and most importantly, if they need to do any Medicaid planning and to join a pooled income trust, that gift writer is extremely important. Off-the-shelf power of attorneys, these you might be able to print off LegalZoom or go to like a stationery store. Those usually don't have the gift writer. Those also don't have the extra modifications. I strongly recommend, I think it makes sense for if you're reaching out to somebody to do a power of attorney, look for an attorney who practices in this area, someone who does elder law estate planning, someone who's willing to, follow through with your power of attorney and make sure it gets accepted at institutions when you bring it to them. I just find that a lot of time the off-the-shelf one, or when you have an attorney who kind of does a little bit of everything, you don't always have the best results, and you can create more problems later on. So that's the basics of the power of attorney. So just to repeat it, power of attorney is you appointing somebody to act in your place when you no longer can. All right. The next document is your healthcare proxy, also extremely important. In your healthcare proxy, you're going to be appointing somebody to be able to make healthcare decisions for yourself in case you are unable to. In the healthcare proxy, you could limit or specify certain things such as life-sustaining treatment and donations. I have found in my experience, and I think I worked with Michelle already for about 3 years, I try not to specify or limit the authority of your agent. I find that it's such a for everybody as they get older, as if they're sick, the healthcare decisions are so fluid and so hard to limit in a certain specific situation that it is better to have, at least in my opinion, a very detailed conversation with your agent, making sure that they're aware of what you want and what your intentions are, and this way they can make a decision with that in mind. I've found that by trying to limit things as such as, for example, no artificial nutrition or no life support, no intubation, on paper or in one example, that may be your intentions and may carry out your wishes. But I've seen sometimes with that limited, there are times when intubation is necessary and a person may have, months or years to live. And without the agent having the authority to do so, they may not be carrying out the actual wishes of the client. So I usually recommend my clients to not limit their decision-making ability of their healthcare proxy, but just to have a very open and frank conversation about what their situation is and how their disease may progress and what choices they may want made for them. There's also the MOLST and DNR form. The MOLST form is a form you can, if you, medical directive for life-sustaining treatment. There you can dictate what you want in terms of life-sustaining treatment, artificial nutrition, and machine support. And the DNR is a do not resuscitate form, another form that one can fill out, which would state that a person does not want to be resuscitated under any condition. My experience has been, I do try to shy away from those. I'll give you an example. I once had a client who had a DNR. He was home with his aide. He had choked. The aide did not, fortunately, the aide did not comply with the DNR. The aide called 911, an ambulance came, and they were able to resuscitate him because he had choked on some food. And he lived about another year and a half. And he had told me later that his intention of the DNR was if he had, had a heart attack or something like that, and he was kind of basically maybe physically gone, he wouldn't have been wanted resuscitated. He was happy that his aide didn't follow through on it. So that's an example, or sometimes the one example you're thinking of where your DNR or your life-sustaining treatment may apply, just make sure you're thinking of all the other conditions where it may apply, and it may have a different outcome than you expect. All right. So that's what a basic estate plan here is in our firm, right? That's the will, healthcare proxy, and power of attorney. That would take care of the basics. It would make sure that as a person starts losing physical or mental capacity, they would have someone in place to take care of their legal and financial decisions. It would make sure that there's someone appointed to make healthcare decisions for them in case they no longer can. And also make sure that at the time of passing, any assets that are not passing automatically outside of probate, you appoint an executor, and you've made the determination of who's going to receive it, and you may have also appointed a guardian for your minor children. So those are the basic estate plan. So then I want to jump ahead to long-term care. So we're going to talk about what long-term care is, how it's defined. We'll touch onto it a little bit. Then we'll talk about how we can plan for paying for long-term care and things like that. So first, let's talk about what is long-term care. So long-term care is not short-term care, obviously, right? So short-term care is something people are familiar with. After a hospital stay, if somebody requires any sort of rehabilitation, usually they'll be transferred to a rehab center, a nursing home and rehab center, but they're in the rehabilitation part. Medicare covers a short-term stay. A short-term stay is defined as 100 days or less. In that situation, Medicare covers the first 20 days at 100% coverage, and then to day 21 to 100, Medicare only covers 80%. And the 20% would either be if you have a Medigap or supplementary insurance, they would cover it, or someone would have to pay that co-insurance by themselves. So that's what a short-term stay is. Anything over 100 days of care, whether it's in an institution like a rehab center or a nursing home, or at home with a home health aide, that's what's considered long-term care. Medicare does cover short-term care at home under a certified home health agency. So after a hospitalization, or if someone is prescribed by a doctor that needs some home care, they would be able to receive a limited amount of hours. It's usually capped around 20 hours a week for up to 90 days for a short-term home care at home. So that's not, we're not really talking about, because that happens automatically. You don't need any planning for that. That's between the healthcare providers, the social workers, and the agencies when you're dealing with that. So let's talk about the types of long-term care and what might be the best type of long-term care for you. So on the highest level is a skilled nursing home. This is a nursing home. This is they're licensed to provide skilled nursing. You're getting advanced medical services. You might be getting some rehab and therapy. They provide your meals. There's a 24/7 nursing team, and this is generally suitable for somebody who has serious medical conditions. I'll tell you on my end, I try to steer my clients away from skilled nursing homes as much as possible. I find just being at home with the care is usually a more comfortable situation, but it's obviously everyone's, different medical conditions sometimes require a skilled nursing. So that's the high level of care. That's what a nursing home is. A little lower level of that is an assisted living. This is usually you're living in a communal setting. You have your own room or private room, something like that. This is good for people who are aging but don't have a serious medical condition. They can still care for themselves. They might need a minimal amount of support. It's helpful. They're getting some assistance. You're getting some supervision. This isn't really for someone, obviously we're speaking here at the ALS Summit. Assisted living usually isn't going to be a good option in the long term. It might be for a very short time, something that's doable for somebody, but I would only use this in a very limited amount and really plan for a longer. The assisted living won't allow someone to age in place. Usually most assisted livings don't have the right licensing to be able to allow someone to age and to need the high level of care that's likely to be needed as their disease progresses. The next level of home care level of long-term care is called home care. So this is when you're still living at home in the community. Care is given inside the patient's home. You can receive up to 24-hour care at home. The highest level of care would be, around the clock, 24/7. So that's 2 different aides coming in 12-hour shifts. Though that's a very high standard of care. Usually we're seeing people getting a live-in shift of a 24/7. Somebody's sleeping through the evening and the client is being able to sleep through the night. This level of care obviously can be quite expensive. You're paying usually by the hour, by the day. We prefer this. We find that the one-on-one care at home is usually the best outcome. Our clients are still in their home where they're comfortable. They still have control over their visitation from family, their own meals, their schedule. They're still in charge. Compared to the nursing home, once you're an institution, you've kind of given a lot of control up. They're going to decide when you're eating. They're going to decide who can visit you, what hours, how you can leave, and things like that. So generally, we really try to push to have our clients stay at home for as long as possible. Most often, my clients are staying home. I would say over 95% of my clients are able to age in place, to get their care at home in the most comfortable setting for them. Okay, and I apologize if I'm going kind of fast. Michelle hasn't interrupted me and told me I should slow down, so that's good. Okay, so let's talk about ways to pay for long-term care. So Medicare is not a way to pay for long-term care. Medicare, like I said earlier, does not pay for long-term care. They only cover short-term stays. So Medicare is out of the question. Long-term care insurance. So if you were lucky enough to purchase long-term care insurance while you were still healthy and young, a long-term care insurance policy might cover your cost of care, whether at home or institution. There's private pay and Medicaid. So let's talk about long-term care insurance first. First of all, the cost, quite often we find, if you were lucky to do so or if you're considering it, is usually quite expensive. There are some limitations in waiting periods. We've seen some policies that have 90-day wait periods, meaning you would need to pay for care privately first for the first 90 days, and then you'd be able to, then the insurance would kick in. We've seen limitations where people purchase policies maybe 20 years ago, and those policies don't have a rider for inflation. So that would mean, maybe in the year in 2001, cost of care for a full day of care may have been $250 a day, or today that's costing you $350 a day. So your insurance may only cap at the $250 and not the $350. These are the issues we see. If you do have a long-term care insurance policy and you are hoping to rely on it, I strongly recommend you have someone review it for you. My office will do it for you. An elder care attorney should be able to review it for you. One of the social workers, the plan himself, anyone like that should be able to review it for you and tell you if it's going to do what you're hoping it does for you. You don't want to be relying on it and then finding out later and then be scrambling for other options. Private pay, obviously, is the next option. So here's just some examples of what nursing homes cost around here in New York State. If you see there in Long Island, I think is the most expensive. It's about $160,000 a year. New York City, 154,000 a year. If you want to go, all the way central region, or, the way upstate, you're looking at about $125,000 a year. So obviously nursing home care is very, very expensive, usually not sustainable in the long term. We're not going to talk too much about nursing home care in this presentation. There are ways to get Medicaid to pay for it. It's a little more complicated, and I think it's more of a one-on-one conversation, but we'll talk about it in a little bit. Home care. So I think these rates are still valid. These are the rates that, we've been getting quotes from our vendors. Here at the summit, you may have seen At Your Side Home Care, or different organizations, Teresa Home Care. I think these might be their regular rates, but you're looking at $25 to $30 an hour. A 12-hour day is about $300 a day, right? So as you see there, if someone's paying privately, they're going to be spending $9,000 to $10,000 a month. For most people, that's not sustainable in the long term. As we've seen clients getting home care for years. So paying privately is usually not an option in the long term for most people. So the best option, or the option that we try to recommend for everybody, is Medicaid. So we'll talk about what Medicaid is, how to qualify for it, and things like that. Let's go into there. So let's talk about the types of Medicaid. So you have the New York State Healthcare Exchange. This is also considered called Obamacare, or through the marketplace. This type of Medicaid is for individuals who are under 65 and not disabled. The legal terminology is called MAGI, Modified Adjusted Gross Income. Basically what that means is the state is looking at only your income for the year. Your Modified Adjusted Gross Income is a number off your IRS 1040. They're not looking at your assets or anything like that. There's no sort of asset limitation you can have. A person can have an unlimited amount of assets, but the state is only looking at your annual income. So this, for most people here who are joining this session and the summit here, once a person is deemed disabled and collecting Social Security, they would no longer be able to, they should not be able to continue getting services through the healthcare exchange. Though we've seen sometimes people have been on it, and you would not get any home care services through that. So that's the healthcare exchange. Next one is the institutional nursing home Medicaid. This is, as I mentioned earlier, is somebody going to a nursing home. This one is a little more complicated because for someone to do so, when you apply for nursing home Medicaid, there's a 5-year look back period, which means that Medicaid is going to review your finances for the last 5 years. This usually makes it costly to need nursing home care within those 5 years, but there are some emergency planning we can do. Stuff called gift and promissory notes, transfers to spouses. We're not going to get into too much detail of that because, like I said, that could be its own 1-hour discussion. And then the other type of Medicaid is community Medicaid. So this is when you're still living in the community, living at home or in an assisted living facility, and you're receiving the home care hours at home. This is going to be done through your local DSS, your local Department of Social Services. If you're here in the 5 boroughs, it's also known as Human Resource Administration. And for that, there are certain qualifications you must meet. There are income and asset qualifications. So let's jump into that. So for community Medicaid, there's a 2-part test. There's an asset test and there is an income test. So we're going to talk about the asset test first. So I rounded the numbers just to make it easier for you. A single person applying for Medicaid is allowed to have about $15,000 in countable resources, and a married couple, if they're both applying, and they're over 65, then their limit is $23,000. So let's first talk about what Medicaid. So what is considered a countable resource and what's not. I'll start first. What's not accountable resources. So what's not accountable resources is your primary residence, valued to about $900,000. Of equity, your retirement accounts. So whether it's IRAs, 401k, 403bs, deferred compensation, deferred annuities, any of those, as long as they're in payout status, which we'll talk about in a second what that means, but as long as they're in payout status, Medicaid does not look at that resource. So you could have a $900,000 home, you could have $1 million in your IRA, And if you're a single person, you could have $15,000 in your checking account, and that's all you have. And as long as the IRA is in payout status, you've now passed the asset test for Medicaid. So what does count as an asset? So here's a list. We see there stocks, bonds, investments, vacation homes, second homes, investment properties, checking accounts, savings accounts, anything like that. Anything that life insurance policies that have cash values, anything that you could technically cash out does count as a countable resource. Prepaid funeral arrangements aren't counted towards it. Your car is an exemption. We'll go through those details. So let me just go over how we do that. So obviously these limits are usually are most people, at least in some form or way, are going to, without any sort of planning or just looking at their statements today, are probably over these limits. And so how do we handle that? So one way to do it is we want to reduce your assets. So like I said earlier, if you're single, it's $15,000 in countable resources. If you're married, it's 23. So let's say someone has more money than that. What do? So we want to reduce your assets, and there are a few ways to reduce the assets. One is to, let's say, gift the money to family. So if you're married and you're the only one applying for Medicaid, so you'd be applying for Medicaid as a single person, you can gift over all your assets over to your spouse. It's now your spouse, it's not yours, and you can apply for Medicaid. Let's say you're not married, or let's say your spouse is applying for Medicaid with you too. Another option is you can just gift the money over to your children. You have, the money's going to your child or to your 3-4 children. Let me just give them in advance right now, whatever it is, and you can do so. You can do so. Currently, you can do so. It won't affect any of your planning or Medicaid like that. We'll talk about a little bit starting July, how that may not be a good option for you. But let me talk about some of those pitfalls of gifting it to your family. So first of all, once you give it to your family, it's no longer yours, right? Legally, if you give it to them, it's their money. If it's not their money, then you've now violated Medicaid's rules, and your money has to be counted. So once you give them the money, that's their money. That means if they want to, spend it on a cruise, they want to, if they're getting, God forbid, they're getting divorced, or they're having financial troubles, they have creditors, there's a substance abuse issue, or drugs, alcohol, anything like that, that's their money, and that could be gone. So that may not be the exact outcome you want. We really want to make sure we're doing that. In addition, let's say the assets you have, let's say it's a brokerage account, so you bought some Amazon stock in 2005. It's gone up, maybe, 10,000% since then, right? If you were to gift that over to your children today, it would be gift over to them tax-free, but when they sell those stocks, they're going to be paying an enormous amount of capital gains on the appreciation. Generally, when you have appreciated assets, whether it's a home, a second home, stocks, anything like that, we want to avoid gifting it to somebody. If we can, we want it to be that they inherit those assets, because when you inherit an asset, you get something called a step up in basis, which just basically means that the appreciation of the assets it just is erased, and your beneficiaries receive it at the current cost at date of death, and all that appreciation is given to them tax-free. So before you, I don't want you to be, after you hear this, say, hey, I know what I need to do for Medicaid. Let me just transfer everything over to my child, these appreciated assets to my child. I don't want to do any other more expensive planning. Realize that the cheaper option today may end up costing thousands and thousands of dollars more in the future in terms of taxes and things like that. So that's why it's not always the best option, but every situation is different, and really you should discuss it with an elder law attorney. Another option is transferring it to a trust. So let's just talk about what a trust is and different types. First, let's talk about what a trust is. So a trust is a legal entity. There are 3 parties to a trust. There is the creator of a trust, creator or grantor. There is the trustee, and then there are the beneficiaries. Now, there are 2 types of beneficiaries. There's a lifetime beneficiary, and that means that's the beneficiary while the creator is alive. And then there is the future beneficiary, and that's the beneficiary who receives everything at time of death. All right, so if I were to create a trust, and I were to appoint my brother as a trustee, and my children are the future beneficiaries when I pass away. So I'm the creator, my brother is the trustee, and my children are the future beneficiaries. I would be the lifetime beneficiary. So let's talk about different types of trusts. You may have heard these terms. There's a revocable trust and an irrevocable trust. It doesn't look correct. So on the revocable trust, this is a trust we don't recommend for Medicaid planning. Revocable trust is good for avoiding probate. What that means is that, let's say you have real estate or financial accounts and you don't want any beneficiaries on them. By putting the property in a trust, at the time of your passing, the asset passes automatically. There's no need for any court intervention. It's a very seamless transfer of assets. It's all done privately, and it's great for that. On the West Coast, wills aren't really common. If you have any family from California, everybody has revocable trusts. No one does wills. Here on the East Coast, we do more wills and less revocable trusts. A revocable trust also gives you full access to your assets. So that means if you're the creator of the trust, you could be the trustee and you could spend that money in any way you want. Now, the downside of that is that there's no creditor or Medicaid protection. In a revocable trust, if you apply for Medicaid and you transfer your assets into it, the assets in the revocable trust are still considered yours. Medicaid would deny you for services because you still have full access to it. There's no creditor or Medicaid protection. So that's why we don't use a revocable trust in our planning tools. Sometimes if you have a revocable trust already and your assets are there, they're amendable. We can amend them to make them Medicaid compliant, to make them irrevocable. Or sometimes we have clients who are in the beginning parts of planning and are not ready to do an irrevocable trust. So they may create a revocable trust at first and later on amend it. But that's more case specific. The other type of trust is an irrevocable trust. So some important parts of an irrevocable trust is you, the creator, cannot be the trustee. You do have limited access to the assets inside the trust. In fact, you have no access to the assets in the trust. You only have access to the income earned off of it. Specifically, it's an income-only trust, meaning that you only have the right to benefit from the assets in there from the income producing. So if you put property in there, you have the right to live in the house. That's considered an income benefit. If you put in, some stocks in there and they pay dividends, you're able to receive those dividends. If you put in assets in there that appreciate, and that appreciation, you're able to receive that income. But the principal amount that we put into the trust, that money is locked up and unavailable to you. Now, the benefit of doing that is that you now get creditor and Medicaid protection. Because you have no access to the assets in the trust, that also means that your creditors and Medicaid cannot say that those assets should be considered yours and we should have access to it. So the irrevocable trust is really the only tool that's available to somebody who wants to have some control over the assets, not give it away during their lifetime. They want to be able to control who's going to inherit when they pass away and things like that. Let's just talk about what in the trust you can do. So in the trust, you're going to dictate who receives the assets when you pass away. You do have the ability to change those people, what's called a power of appointment or a limited power of appointment. So sometimes our clients ask us questions that, I'm trying to, I think I'm giving it to my children, but what if I change my mind? How do I make sure my children follow through with my recommendation and things I want them to do? So I tell them with a limited power of appointment, you always have the ability to disinherit one of your children if something comes up, or if their situation changes. Let's say they become disabled, or they're going through a divorce or financial trouble, drugs and alcohol, any of these things, you as a creator of it still have the authority to make those changes, and it won't affect the validity of the trust. Okay, so I'm going to go back over here earlier. So earlier when I said there was an asset test, I said that your home is not a countable resource, right? Valued up to $893. So let's say $900,000. There's no problem. You can qualify for Medicaid with having a home valued up to $900,000, basically. Now there's a big caveat. Hopefully no one heard that part and signed off. The caveat is this. So even though owning a home is not an obstacle for Medicaid, planning is still needed, and I'll tell you why. So at the time of passing, Medicaid, if that home is probatable, meaning you own it yourself or your spouse is also on Medicaid, Medicaid has a right to put a lien either on the house or be a creditor to your estate saying, we've provided services of X amount of money to the deceased, and now that there's an asset in their estate, we want to get paid back. So you want to make sure that even though owning the home is not an obstacle to qualifying for Medicaid, if you own that home at time of passing, and it's going to go through probate, or it's still part of your, if you're still part of your estate, then Medicaid has a right to put a lien on it, and they most likely will. And you're basically going to pay them back every penny that they've laid out for you. So always make sure that if you own a home, we see this sometimes when people are getting their Medicaid applications done in a non-legal setting, whether it's a hospital, through an agency, and they're just going to just, get it done, and they don't want to wait, and they're not equipped to do the transfers of the home or the trust planning. They will tell the client that it's okay, you're eligible for Medicaid. We end up getting a call years later when someone passed away and saying, hey, my mom and dad passed away, we're doing probate, and now Medicaid wants us to pay back $350,000. What do we do? And unfortunately, at that point, where we were called too late. So if you even though Medicaid, owning the home is not an obstacle, you do have to do some planning with it.
Alicia, can I just jump in? So
Yeah.
if in that situation, they did put the house or condo in a trust upon the passing of the person, then it's not, it can't be put a lien on by Medicaid?
Correct. So once it goes into an irrevocable trust, it's not considered your asset, and Medicaid doesn't have any rights to it while you're alive or at passing.
Okay, thank you.
No problem. Okay, so I'm gonna go back. I see someone raise their hand. Michelle, should I be answering questions, or? Oh wait, Michelle, you're mute. I don't hear you.
Sorry about that. We're going to do most questions at the end, but it's a lot of information. So do you want to pause for a second and take one or
Sure.
two questions?
Okay. So I'm gonna Nua, I'm gonna allow you to talk. Go ahead.
I don't know if that's a function. Can we? I think
Yeah.
they're going to have.
Nua Nikaj, are you there? You raised your hand. You have to unmute yourself if you want to be able to speak. So Nua, unfortunately, I'm not able to understand it. Maybe you can type in the question and we'll answer it at the end. Or we have someone monitoring the chat features and the Q&A. So that might work for you, okay?
Yeah. So Alicia, at this point, if people can type in the question, that would be good. If there's going to be any sort of interaction, we'll do that at the end.
Okay. And if any of those questions you feel are relevant, I should stop. Just interrupt me, and we'll answer those questions.
Okay. Before you go to the next step with Medicaid, Meg, do you want to pop on and ask the question about power of attorney?
Yes, I can. So we do have a question right now. It says, you stated that power of attorney designates someone to act in your place when you no longer can. I understand the impression that even if one remains able to make their own decisions, once a power of attorney document has been executed, that the POA has the right to make the decisions on behalf of the person, naming them equal to that individual. Is that not true?
Yes, that's correct. I'm sorry if I said that earlier. So if I said earlier that it only comes into play when you're no longer able to, whoever asked the question is correct. Once you sign the power of attorney, even though you have full capacity, the agent does have the authority to act in your place. The agent's authority does not diminish your own authority. So even though you may have appointed someone to be able to act in your place, it does not interfere with your own ability to make those decisions. Hopefully that answers the question. Okay. So I mentioned earlier that Medicaid has a two-part test, right? I said it has an asset test and an income test. So we just finished the asset part, right? So it's a $15,000 limit for a single person or a person only applying by themselves under a spousal refusal, which we'll talk about in a little bit, or $23,000 for a married couple. You reduce those assets by either transferring out of your name to a family member or to someone else or into a trust. And that's the asset test. Now on the income side, let's talk about the Medicaid's income test and what they require. So there are solutions to all this, so don't freak out about these numbers. So a single person or a person applying by themselves as a single person, your limit is only $904 a month. A married couple is $1,320 a month. So let's talk about what's considered income. Basically, anything you get regularly is considered income. So Social Security, whether it's regular Social Security, SSDI, disability payments, pensions, required minimum distributions from your IRAs, annuity payments, any sort of income, any of those things are considered income. Anything over that limit is considered surplus income. Medicaid labels that surplus income or excess income. So obviously, there are very few people who fall under these categories without needing some help. So let's talk about what you can do with those. So Medicaid gives you two options. One very bad option is, let's say you're a single person and your income is $2,904 a month between all your different options. So Medicaid will say that your surplus income is $2,000. One option is to give the income to Medicaid, pay it over to Medicaid, and now you don't have any surplus income and you qualify. Obviously, that's not a great option because it'd be very hard for anyone to survive on such a low amount here in anywhere in New York or anywhere in the East Coast. So the other option Medicaid gives you is the ability to shelter your monthly income into something called a pooled income trust. So a pooled income trust is run by a charitable organization. They're a special needs trust, and their sole purpose is to shelter the surplus income for individuals who are in Medicaid. Medicaid's actually aware of this. Medicaid will ask proof of it. And so let me tell you how it'll work. So example I gave you earlier, $2,904 in income. The individual is $2,000 over the limit. What Medicaid allows you to do is to establish this pooled income trust with the charitable organization. You have an account with them. You would still receive your $2,904 every month into your checking account. There'd be an automatic withdrawal to the pooled income trust account of $2,000. Medicaid would ask proof of that and say we're now discounting your income by that $2,000. Your income is only $904. You now qualify. Medicaid has no limit on how much you can shelter. So if you're $5,000 over the limit, $10,000 over the limit, doesn't matter. Your surplus income can go into this pooled income trust, and Medicaid will discount that, and you have now passed the income test for Medicaid. Now, that money in the pooled income trust is money available to the member for any bill in their name. So you still have the full financial benefit of your money. You're just not the one writing out those checks. So the money in the pooled income trust has to be paid out to a third party for an expense that's yours, whether that's going to be rent, mortgage, property taxes, cable bill, cell phone bill, credit card payments, for current credit cards, car payments, car insurance, right? Anything that your name is on it, it's your money. They'll write a check to them. The pooled income trust will also give you like a debit card to do your smaller transactions, your grocery stores, your shopping and things like that. So you don't have to, submit a bill to pay Stop and Shop or something like that. So by putting the money in the pooled income trust, you're sheltering from Medicaid. Medicaid counts it as not yours, but you still have the financial benefit. You cannot write out, checks to cash from there. You can't withdraw cash from the pooled income trust. You can't write out checks for someone's birthday. You can't write out checks to charity. It has to be for an expense to a third party. Whatever you don't spend carries over to the next month. So let's say you're putting $2,000 a month in there, but in the month of June, you only had $1,500 of expenses. So that's $500 carries over to next month. So the pooled income trust allows somebody to qualify for Medicaid, even though their income is higher than the allowable amount. All right. A lot of questions people ask with that is what happens at time of passing. So with the pooled income trust, at the time of passing, if there's any money left in that account, they usually give you like a 2 or 3 week period where you can submit bills that were incurred before death. And then anything left over goes to the charity that runs it. That's the tool that Medicaid has put into place. Generally speaking, I've seen that the money is a wash. Our clients are putting money in and the money's coming right back out. If not on a monthly basis, at least on a quarterly basis with their quarterly payments. It's, with taxes and things like that, the money is usually, coming in and coming out, and there's very rarely ever any amount being left in there. Even in a situation where someone does not have enough expenses, the money left over in there is still going to be a fraction of what one might pay to pay for care privately. So even if someone is leaving over there $1,000 a month and can't find $1,000 extra of expenses to use, if they're receiving 24-hour care at home, they would have been paying $10,000 a month for that. Here, at least, there's only $1,000 going to the thing. But like I said, usually that we find a way to spend that money for the client's benefit. So let's recap the two-part test. So the asset test and the income test. Now, I touched on one point, and I mentioned here on the income is your IRA RMDs, and I mentioned earlier that your retirement accounts has to be in payout status. So let me tell you what that means. So your RMD is, if you may be aware of it, it's called a required minimum distribution. That's only required when you turn 72. Going forward, it's 72. You're required to take out a certain amount every single month. If you are under 72 and you're in the 5 boroughs, you're in New York City, then we create an artificial RMD. It goes by the life expectancy from an IRS table from 1996. Ends up being somewhere from 3 to 5%. You have to take that out on a monthly basis, and then. So if you have $100,000 in your IRA and your RMD ends up being, let's say, $6,000 for the year, you would be taking out $500 a month. By doing so, it's considered in payout status, and Medicaid will ignore the balance in the account. If you're not in the 5 boroughs and you're anywhere else, you have to take out what's called the maximum distribution, which is another percent or two higher. It's a different calculation using a different table. Different counties are using different tables. One are using the Social Security table, and one is using the IRS's table. So depending on your county that you're in, the number may be a little different. But that counts as part of your income. But then you would be protecting the balance in that retirement account. So that's a 2-part test. You would shelter your excess income in a pooled income trust, and you would protect your assets by transferring them out of your name or putting them into an irrevocable trust. Now, I mentioned earlier that if you're married and your spouse is still working or not going to apply for Medicaid, you would have to apply as a single person, and for Medicaid to only count your income, you would have to utilize a tool called spousal refusal. So the spousal refusal form, let's go backtrack a little bit. Under the laws in New York, if you're married to somebody, you're responsible for their medical care. So if you have, let's say we have a husband and wife, the husband has ALS, the wife is still working, the wife's income is going to count towards his eligibility for Medicaid. The only way the husband who needs care is able to apply for Medicaid and not have his spouse's income interfere with him would be if they sign a spousal refusal. So the spousal refusal form is saying that basically the wife is saying, even though I'm required by law to pay for my husband's care, I'm refusing to do so. And I want Medicaid to count him as a single person. And by doing so, Medicaid will process the application as if the husband is single, only look at his income and assets, and then qualify him for it. And this is how we're able to overcome that obstacle. But on that document, and this is, you have to remember this, is that you state in there, Medicaid has the right to seek reimbursement from the well spouse as long as a person is alive. So that means the spouse, the working spouse, or the well spouse, in this case, the wife, while her husband's getting care, Medicaid can seek reimbursement from her and ask her to pay them back for every penny they've paid out. Now, when they do that sort of investigation, what they're looking for is another legal terminology called spousal impoverishment rules. They're not looking to impoverish the spouse, but if you have more than their impoverishment limits, they're going to ask you to contribute that. So in the case of this husband and wife, it's roughly the wife's allowed to have $3,200 a month in income. Anything over that amount is considered money available to pay Medicaid back for his care, to contribute to his cost of care. And Medicaid would ask you to pay back 25% of that. So let's say our wife has $4,000 a month of income. So she's $800 over that limit. I'm using round numbers. I'm not giving specific numbers because that's way too complicated. But that means there's $800 left over of available income. Medicaid would ask you to contribute $200 a month of that to reimburse them for the cost of care that laid out for him. That reimbursement would be until the debt is paid off. So it's a lifelong debt that you would have to pay. In terms of assets, Medicaid is looking at roughly $70,000 of assets the well spouse can have, or if they own assets together, it could be up to $120,000. Anything over that amount, Medicaid considers that money available to them to pay them back. If the well spouse has any dependents or children that they're supporting, Medicaid allows you to get an additional $600 per child. At a maximum, I think it's around $5,000 a month. So the reason why I'm mentioning this is that generally this has not been this is a very underutilized tactic of Medicaid. Medicaid is not very often going after the well spouse and asking for reimbursement. Probably somewhere, I would say around 5%, definitely not more than 10% of the time. My concern is there have been changes to Medicaid. The state, and we're going to talk about it a little bit, the state is making Medicaid a little harder to, community Medicaid to get. They're adding more barriers because the state is not doing well financially. And my concern is that 5% number may start increasing because Medicaid, the state needs money and they're going to start going after people who can reimburse them. So some of you may be hearing this and saying, so, what do I do then? I'm still working, my income is higher, my spouse needs care. Like I'm just going to give up. So even if there is no other option but the spousal refusal, first of all, it's only a chance that Medicaid may seek reimbursement. It's not a guarantee. But even if they ask you to reimburse you, it's going to be at a lot lower rate than the private pay is. So I told you earlier that Medicaid's private pay is about $10,000 a month for home care, let's say for 24-hour home care. So using that number, Medicaid's rate might be a lot lower. Medicaid might be only paying somewhere around $6,000 or $7,000 a month for that same level of care. So if you have to reimburse Medicaid, it's going to be at that lower rate, which is lower, it's cheaper. So if you do the spousal refusal, you have the chance of you won't be selected for reimbursement. And even if you are required to reimburse it, it's at the lower rate. And even then it's over a long payoff period. It's not $10,000 every single month where you have to cash it out. Medicaid can wait 20 years for you to reimburse them over it. So it's more of a payment plan. So it's still an option, though obviously not the ideal option, and things like that. Okay, so here's some changes coming in July. These are very big changes. So these were changes.
One second, Elisha, before you get into the big changes, because that's so important, I just want to let everyone know that our session is coming to a close soon. So while Elisha talks about the important changes, and I do want you to pay attention, if you have any questions that you would like to ask, if you can put them in the chat box, that would be great. Okay, thanks, Elisha.
Thanks. Okay, so here's the changes. Right now, you can have any money you have in the bank, we can move it out of your name into a trust in the family member's name. And next month we can apply for Medicaid. There is no look back period. So you could be a millionaire today in the month of April. We could help you move things around. And then next month, May 1st, we can apply for Medicaid, showing your assets are only $15,000 and you've qualified and there's no issue with it. Coming July 21st, this was supposed to happen last October of 2020. It was pushed off. It was supposed to be April 1st and they pushed off against July, and they are likely to push it off again to at least October because the law is Medicaid can't make any big changes while there's a public health emergency, which obviously COVID is. But right now we have to plan for as if July. So there's going to be a look back period, and it's going to be a 30-month look back period. So what that means is when you apply for Medicaid, Medicaid is going to ask for your finances going back 30 months, but not past October of last year. So if you're only applying July, let's say July of this year, you would have to submit all your finances going back to October of 2020. They're phasing in this 30-month look back, this 2.5-year look back. And what Medicaid is looking at is they're looking to see for every transfer you've made, you're going to not pay for your care. So roughly the number is for every $11,000 of money you've given away in a non-exempt transfer, Medicaid's not going to pay for 1 month of care. So if you had $110,000 in your checking account, you transfer it over to your son living outside of the house, you are now ineligible for 10 months of care. So if you applied October to 2021 and that's what happened, Medicaid would not kick in until June 2022. For 10 months, they won't pay for the care. There are some working around it. There are some exempt transfers. Exempt transfers would be transfers over to your spouse are exempt, transfers over to a child, disabled child who's living with you, or an adult child who's living with you. You can transfer your home. There are some things we can talk about. There is some emergency planning that we can do, that we can shelter some of the income or what that penalty period will be. But this is going to be a huge change. Like I said, up until now, that look back period was only for nursing homes. And that was a 60-month, a 5-year look back period. Or for community Medicaid, there's going to be this 30-month look back period. So if you're at the point in your, if you're sitting here and you're reminded thinking, well, I don't really need care right now. I mean, I could probably use a little bit, but I may need it, not right now, but I probably really need it 6 months, a year from now, something like that. I would say if you think the next 6 to 12 months you're going to need some sort of home care at home, now is the time to move, because it's going to be a lot easier to qualify. You'll be grandfathered in and you don't have to worry about it. After this change takes place, you're going to be penalized for those transfers you made for the planning that we're talking about. There's a chance you're going to be penalized if you don't have a way to exempt your transfers. So this is extremely important. Luckily, it was pushed off from the beginning of this month. I do have a feeling it's going to continue to be pushed off, but don't rely on that. Wherever, now the time to speak to an elder law attorney about this. I would say my office is available, but really whoever you're dealing with, make sure they're an elder law attorney who qualify this. So let's say you need care. Now what do you do?
So,
Yeah.
Elisha, we actually have a hard stop at 6 o'clock, I was told.
Okay.
So if you can put up your contact information. I have one question that I think we need to address before the 6 o'clock kicks us off is, can you talk about doing an expedited Medicaid application, what that means compared to the normal process of doing a Medicaid application?
Okay, great. So generally speaking, when you apply for Medicaid, a regular application, Medicaid's going to take somewhere from 60 to 90 days to process the application. So we have seen a little faster times recently due to COVID. We're just rubber stamping things. But when usually we apply for Medicaid, we're applying under the immediate needs process. And what that means is that we're telling Medicaid that you need care right away. You don't have the sufficient care you need. And that forces Medicaid to process your application in 2 weeks. Specifically, it's actually 12 days. 12 calendar days you're required to process your application. And once they process your application, they're supposed to start providing services through the local district while you're waiting for enrollment into the managed long-term care. So we didn't go into detail about the MLTC, which is the managed long-term care. That's the HMO version of Medicaid for long-term care. But we didn't even talk about what they cover. But so I'll tell you briefly. Once you're on Medicaid, they cover, up to 24-hour care at home. They'll cover your ambulance service, medical to transportation to all your appointments. They'll cover your durable medical equipment. You can use them as a Part B provider. Medicare will still be your primary insurance. You won't lose your doctors. You won't lose any of that stuff. I wish I had more time, but if the only thing you're taking from this whole long thing is Medicaid is almost 99% sure an option for you. Anyone telling you otherwise, you should really speak to and make sure it's elder law attorney telling you don't qualify. But you can call my office. We do free consultations. We do stuff over Zoom. We make home visits if necessary. We have offices in Nassau, Queens, Brooklyn, and Suffolk County. We do Westchester. We do Manhattan. We do Staten Island. We make it as convenient and available for you. You can email me also. It's Elisha@WellersteinLawGroup.com. You can find us online. And that's it. I know we have I see a question coming up over here.
At this point, we're actually a minute in. I think the person that tried to ask a question before, I'm just going to have them reach out to you directly to do a consultation. And thank you so much for your time and your presentation. It's always valuable. Anybody on here, please feel free to listen to the recording or send questions to Elisha or myself.
All right. Thank you, everybody. Have a good night.
We're out of time. Thank you very much, Elisha.
Bye-bye.
Bye.